Hearing in the appeal, Commissioners to Her Majesty's Revenue and Customs against Joint Administrators of the Lehman Brothers International.
God. Mr. Goldberg.
The lady. In 1911, Sir Herbert Cosens Hardy, speaking in Cooper, says, "When we get back to the maze of the Income Tax Acts," I've got some news for him. They've got rather longer. When we get back to the maze of the Income Tax Acts, it has been settled for very many years that there is some limit to those words, yearly interest. Lord Justice Patten, in his judgment below, failed to respect that limit. In particular, he made an error at paragraph 57 of his judgment, which can be found in the core bundle at tab 7, page 113. He says, "In my view, it would be wrong to treat such statutory interest under the insolvency rules as a short-term liability of this kind." And then going down to the end of the sentence, end of the paragraph, "Unless the fact that it did not accrue prospectively in real time is fatal to the contention that it is yearly interest, which in the light of the authorities it is not, I can see nothing in the insolvency rules or the other relevant surrounding circumstances which prevents it from being treated as the long-term liability which it in fact was." Now, there's some difficulty in determining what His Lordship means by it there. There are various possible candidates for it. It seems possible that he's referring to the obligation to pay statutory interest itself. However, whatever he's referring to, he's got it wrong, because this is not a long-term liability at all. It is a short or indeterminate term liability, which has no fixed duration unless it be short, and then it has a 20-day duration. I've tried to illustrate the position on the chart that I handed in this morning. My Lords, my Lady, at letter A on the left-hand side, we have the commencement of the administration of LBIE, which we tend to call Libby. A year later, on the 14th of September, what we've called there the normal end of the administration occurs. Under the Insolvency Act, Schedule B1, paragraph 76, the administration is to end a year after it starts. We haven't put that in the bundles in the way these things happen, but I don't think there's any dispute about that. It was, of course, extended by order, as shown in the box below the 14th of September 2009. But the aim of the legislation is that the administration gets over and done with in the year. On the 2nd of December 2009, the administrators were given permission to make a distribution to unsecured creditors. That, I'm told, is relatively unusual in administrations, but it happened in this one. At date B, we've got debts proved on an ongoing basis. Now, this is an attempt to respond to the revenues case here, where they say the source is the proved debts. Now, there is not a single date on which the debts are proved. This is a running date, which can have gone on up until the 20th of June 2018. The 20th of June 2018 is not a magic date. It's not given by hard and fast law, and it's not, in this case, the result of court decisions. It's the result of a scheme of arrangement which is referred to in the agreed facts. But there was a bar date in the scheme of arrangement, and claims had to be made by the 20th of June 2018. So a claim could have been made on the 19th of June 2018. Then we have across the top, between B and C, the dates on which interim distributions were made, and against the entry for the 12th of April 2013, we show that the 9th progress report made the first reference to the possibility of there being a surplus. The statutory interest in this case, of course, is a share of surplus. It's called interest, but in reality it's a share of surplus, and unless there's surplus, nobody gets anything. So by the date at C, the proved debts, the debts that have been proved up until then, have all disappeared. And in our submission, that's going to have two consequences. First of all, it means that the source for the interest has disappeared by 2014. And secondly, it means that the liability to pay a capital sum has disappeared at that date. Date D is the date under which the scheme of arrangement became effective, and we say it is at date D that the source of income arises in this case. It's an unusual source of income because it doesn't have a capital sum. It's a right to be paid statutory interest. But the legislation refers to what the creditors are to get as statutory interest, and it seems right for us to attempt to analyse it in terms that make the designation of it as interest work. So we have identified point D as a source. It is at that stage, and only at that stage, that a creditor knows how much interest he's going to be able to get. Before that, it's all uncertain. It could, for example, be taken away by a winding up. This court held in what I think is called Waterfall 1, that there was a lacuna in the legislation if a winding up happened when the statutory interest in the administration disappeared, and only new types of interest then became payable. So before D, everything is uncertain about this right to statutory interest. And at E, that's the date on which payments were actually made. It's about a month after D, and that accords with the terms of the scheme. So you have before you two competing claims. The revenue, if I've understood their case correctly, say that the source arrives at B and is a source of yearly interest. And we say if it arises at B, it is inherently uncertain and fragile and has no fixed duration, so it is not the sort of thing which can produce yearly interest, which requires something investment-like and permanent-like. And our submission is that the source arises at D, lasts for about a month, and disappears. And we distinguish on the second page of the chart between four different types of liability. We say that there is a liability which, when it arises, is in point of business to last for a period of a year or more, and I shall be taking your lordships, your ladyship, to the authorities, but that is a type of case exemplified by Bebb and Bunny. Then there is a liability which, when it arises, is in point of business of uncertain duration, and that is a case like Gateshead Corporation. Then there is a liability which arises and lasts for a prolonged period, and which, when it is agreed or declared to exist, carries interest for the prolonged period for which the liability has existed. That's like the damages cases, where there is a liability for 7 years. And the fourth type of liability is a liability which, in point of business, I use the phrase in point of business because it's a phrase used in the cases, liability which arises and lasts for a short time, but which produces interest measured by a long period, different from the period for which the liability itself exists. Now, the fourth type of liability is not saying you, the debtor, have owed the creditor money carrying a right to interest for 10 years since the administration started in 2008, measured over the period 2008 to 2014. It is either you, the debtor, have owed the creditor money since 2008, which carries interest to an uncertain date in an unknown amount, or you, the debtor, don't owe anything in relation to interest until 2018, when you must pay it. The court will understand from our submissions that we believe it to be a liability of that second kind rather than of the first kind. But even if it is of the first kind, within the fourth category, it is producing short interest because it is of uncertain and unfixed amount.
Sorry, I haven't got that. The two, within your category 4, you've got two subcategories.
Yes.
Could you just explain again?
Yes. They could be either this: you, the debtor, have owed the creditor money since 2008, which is when the administration started,
Yeah.
which carries interest to an uncertain date, because it only carries interest until if there's a surplus. So we don't actually know if there's going to be a surplus, and we don't know when the interest is going to be paid. It could be paid next month. On the facts of this case, of course, it took years, but that's largely because there was litigation and so on going on. In theory, it could have been paid next month. You just don't know if you say there's a debt beginning in 2008, and you don't know what the amount of the interest.
Yeah, so that's subcategory 1 and subcategory 2.
Subcategory 2 is you don't owe anything in relation to interest until 2018, when you must pay it quickly, which is what actually happened in this case.
Sorry, so there are two alternative explanations of what we've got, you say we have here.
Yes.
Yeah.
Yes, look. But either way, they produce short interest, not yearly interest, because they don't have the sort of fixed duration which it is necessary to have before yearly interest is created. Because as I've noted at the end of that second page, the earlier in the administration the obligation to pay statutory interest arises, the more uncertain and less investment-like it is, because you don't actually know what's going to be paid. Conversely, the later in the process of administration the obligation to pay statutory interest arises, the shorter the period for which it's going to be paid. lasts, and the less permanent and less investment-like it is. Sorts of hopes in chess terms to create a Zugzwang. So, whether one does or not, it's for the court to decide. Lord Justice Patton's reference to the liability being in fact long-term shows that he's asked a question about how long a period the calculation of the amount of the liability covered, rather than a question about the quality and nature of the liability. The cases show that the correct question the court should be asking itself, is about the quality and nature of the liability. And because the Court of Appeal asked the wrong question, it inevitably came to the wrong answer. The question before the court arises from the Income Tax Act 2007, section 874, which is in the first volume of authorities at tab 3. But one doesn't have to go very far into the maze.
Could I have the MS number, please?
313.
Thank you.
This section applies if a payment of yearly interest arising in the United Kingdom is made. We don't actually have to go any further than that.
313.
313.
Ah, thank you.
The person by or through whom the payment is made must, on making the payment, deduct from it a sum representing income tax on it at the basic rate. The insolvency rules are tab 7, page 333.
I may be the only one working from the hard copy, but it'd be useful for me to have the volume and tab number as well.
Tab 7.
Thank you.
First volume, tab 7. So this is the rule that now applies. When this litigation started, a different rule applied, but it was to the same effect.
Oh, I'm sorry, just before we will we be coming back to 874?
Not really.
Could I just...
Yes, if we will.
well, could I take us back to it just for a moment? Just looking at it, I see... It may or may not be of any relevance, but subsection 5A is a deeming provision which requires a payment of interest payable in respect of compensation to be treated as a payment of yearly interest, irrespective of the period in respect of which the interest is paid. So one might take a few points from that.
Five capital A, I see.
Yes.
Well, I very much doubt if any of these payments are to individuals.
Yes. No, the point, well, the one point I was taking from it is that there is a distinction in the legislation between interest and yearly interest.
Oh.
So you can't adopt a definition of yearly interest which would encompass all interest.
My Lord,
That's
yes.
one point.
Yes.
And it's also interesting in that we have obviously some reference to interest being payable in respect of compensation. That's part of one of the situations addressed in the arguments. And it's interesting to see that that's covered by a deeming provision.
Yes.
In other words, it wouldn't otherwise qualify as a payment of yearly interest.
It does, of course, have to be interest in the first place.
Yeah.
Yes.
Yeah. Yeah, thank you.
Do we know when subsection 5A came into, and where it came from? It's obviously an addition. It's footnote 4. It's added by the 2013 Act. Right, thank you.
Told it was introduced to deal with PPI payments.
Ah. Thank you.
Yeah.
The relevant rule in the insolvency rules is at tab 7, page 333. It provides, in an administration, it's sub-rule 7, in an administration, any surplus remaining after payment of the debts proved must, before being applied for any other purpose, be applied in paying interest on those debts in respect of the periods during which they have been outstanding since the relevant date. Relevant date is the commencement of the administration. All interest payable under subparagraph A ranks equally, whether or not the debts on which it's payable rank equally, and the rate of interest payable under subparagraph A is whichever is the greater of the rate specified under subparagraph 6, which is the judgment rate, 8%, and the rate applicable to the debt apart from the administration. And I think that means that the rate can be calculated if the debt provides for short interest. A higher rate if the short interest calculation is more than the 8% judgment rate, which may be relevant to something else which Lord Justice Patten said, because he's assumed all interest is calculated at an annual rate, which I think may not be right. Now, in our submission, the only question before the court arises from the terms of Section 874, read with the insolvency rules, and it is whether the interest is yearly or not. As my Lord Reid has pointed out, it must be interest before it can be yearly. The question of whether tax is imposed or avoided if one answer rather than another is given does not and cannot arise. Whatever answer this court gives to the question of whether statutory interest is yearly or not, the right amount of tax will get paid, because that is how, in the circumstances of this case, the tax system works. The general rule of our tax law is that all recipients of income from UK sources are, no matter where they're resident, liable to tax on that income unless there is some provision which takes away that liability. There is no doubt that the interest here in issue has a UK source, so that in principle, all recipients are potentially liable to tax on it. However, if the interest is short, tax is not withheld from it when it's paid, and non-residents have no liability to tax on it unless they have a taxable presence in the UK. In cases like that, where there's a taxable presence in the UK, tax is collected directly from the UK presence. And we can see that in the first volume of Authorities, tab 1, page 269. That's section 5 of the Corporation Tax Act, and sets out the circumstances in which a company is liable to corporation tax. And it must either have, a non-resident company must either have land in the UK or carry on a trade in the UK through a permanent establishment in the UK. And looking at the income tax provision, we have to go on to section 811, which is at tab 2, page 278. This is where some confusion has arisen in Lord Justice Patton's judgment, paragraph 6. Section 811 says this section applies to income tax to which a non-UK resident other than a company is liable, or a non-UK resident company is liable as a trustee. And then there is a similar provision about companies in section 815 on page 284. And the crux of the provision is section 811.3. The non-UK resident's liability to income tax for a tax year is limited to the sum of amounts A and B. Amount A is the sum of A, any sums representing income tax deducted from the non-UK resident's disregarded income for the tax year, and any sums representing income tax that are treated as deducted from or paid in respect of that income. And then amount B is a liability in respect of non-disregarded income. So if all that the non-resident has is short interest, there won't be any withholding, and there won't be any liability to tax, save in the cases where there's an amount of B, which is essentially where the non-resident is carrying on business in the UK through an establishment, in which case, you have to go through the definition of disregarded income in section 813, and you also have to look at section 835C on page 295.
Do we have to?
No.
Didn't think so. I mean, where do you say Lord Justice Patton went wrong?
Well, he says that the withholding imposes a charge on the non-resident. It doesn't impose the charge. The charge is imposed by the general provisions of the Income Tax Act. It prevents the exemption in section 811 from applying. But if what happens is that what is paid is yearly interest and the payer forgets to withhold, he can then be assessed, he is assessed under section 956, which is on page 323. It's a very important provision in this context.
Sorry, which one is that again?
956, page 323, tab 4 of the first bundle. If I were to take you through it, payers of annual interest have to make complex returns showing what annual interest they've paid. If they don't pay, the revenue can turn up under section 956 and assess directly. So if this is yearly interest and somehow is not paid under withholding, a most unlikely situation, the revenue can turn up and collect under section 956. So in one form or another, there is always a withholding where interest is yearly. The withholding is either because money is withheld from the taxpayer or because the tax that should have been paid on the withholding is collected directly by the revenue under section 956. So one way or another, the revenue are always going to be able to get the tax that's due here, if there is any tax due. And of course, if this is short interest and Libby wrongly withhold from it when they pay, that's not a payment of tax, that's a wrongful withholding which the creditor can claim back because it should not have been withheld. So a wrongful withholding cannot create a liability to tax. It's quite difficult to untangle paragraph 6 of Lord Justice Patton's judgment, but it is wrong to say that the withholding imposes the liability.
But it doesn't matter for the purpose of the argument as to what is, does it? I mean,
well, I hope not, my lord. I hope not.
I'm not quite sure why you're, obviously it's right to be aware if he's got it wrong, but it doesn't affect the argument as whether this is yearly interest or not.
No, one hesitates to say so, but it might affect the approach of the court. If the court thought that one way or another tax would be lost if one answer were given rather than another, it might these days have some peripheral influence on how the court thought. But it can't be so in this case because either way, the right...
Presumably, I assume the revenue are here because they see some advantage to the revenue, only in terms of mechanics.
Well, it may be mechanics, but...
And obviously,
I mean, it's quite interesting. Why have we said in our legislation that short interest received by a non-resident does not bear tax? It's not a usual provision. I asked around the world, do other countries relieve short interest from tax? And I believe the answer is not many. We have sought to obtain a competitive advantage in encouraging short-term deposits in the United Kingdom. That must be the purpose of the legislation. Now, in our submission, the interest paid as statutory interest here is short. Both sides are agreed that the answer to the question of whether it's yearly or not is not to be found by looking at the original obligations owed to the creditors by LBIE. And that is the result of the waterfall litigation, particularly the judgment of Mr. Justice David Richards, as he then was, in Lehman number 5, which I'll be going to in due course, and I'm sure the court is familiar with that passage. It's set out in our case, where the remission is to something created by the statute and not to the original contractual position. Because we're not looking at the original position, the results of this case may, in any particular example, be odd. For example, if Libby originally owed obligations on which short interest was to be paid, it would seem odd if administration turned those obligations into obligations on which yearly interest was to be paid. And conversely, if the original obligations were long, it would seem odd if they became short because of the administration. Both sides, I think, accept that that possible oddity exists because the obligation to pay statutory interest is not the original obligation to pay interest. In our submission, the authorities establish a distinction between a long-term liability and a liability of indeterminate length or short length, which happens to produce interest measured over a long period. Statutory interest is of the latter kind, and that makes it short. Trying to draw some principles from the cases and from the tax acts, it is our submission that before there can be yearly interest, first there must be a source of the interest which will define the period to which the interest relates. The need for source appears to be agreed between the parties. At any rate, in the appellant's case, we set out the need for source in paragraphs 2.4 to 2.5, which are in the core bundle at tab 5. Page 44, and in the respondent's case, at tab 6, paragraphs 16 to 18, on pages 63 and 64. Secondly, there must be a term in respect of which interest is payable, which expressly or by implication will, not may, last for a year or more. That's in order for the interest to be yearly. There must be some kind of fixed term. And thirdly, the thing which produces the interest must be in the nature of an investment by the creditor, something which can be regarded as permanent. Now, the conventional starting point for any inquiry into whether interest is yearly or not is Bebb and Bunny, which is in tab 26 of the first volume of Authorities. beginning of page 473. And I think there was a general election in France which Monsieur Mitterrand won by a very small margin, and he said, well, it was possible to imagine a bigger victory. It's possible to imagine a better guide to what is yearly interest than Bebb and Bunny. It's not very clear, but the point to grasp about it is that the Vice-Chancellor, Sir William Page Wood, has assimilated an outstanding purchase price for land to an outstanding mortgage. And he treats the liability there as a long-term liability, a liability which is certainly going to last a year or more. And he defines yearly interest as all interest at a yearly rate, which may have to be paid de anno in annum. I have the good fortune to have a pupil sitting with me at the moment who is a classicist, and he tells me de anno is ablative, from the year, in annum is accusative, to the year. So it implies that the interest must last for a year or more, and what the Vice-Chancellor is saying is this interest will last for a year because it's like a mortgage. The passages chiefly relevant are on page 474. So that is a case where there's a written agreement providing for interest to be paid on a debt. It creates a lien on the land, and there is at least an implied agreement between the parties that it will be outstanding for more than a year, just like a mortgage. And
says it's interest which may become payable de anno in annum. Page 474, second new paragraph.
may be or become payable, though accruing day in DM, but you have to contemplate the period of the year. May be payable from year to year, so you expect it to last at least a full year.
Well, I was thinking back to your will not may submission as to one of your three key indicators.
Well, I hope to as I say, this may not be the best guide. I'm hoping that as we go further through the authorities, we shall see that what I said is more accurate than questions of uncertainty. As my Lord Reid has pointed out, if interest may become payable, is yearly interest, how do you distinguish it from short interest? There has to be some distinction between short interest and yearly interest. And we're going to discover from the Gateshead case, when we get there, that it is not just things that get repaid within a year that produce short interest. You have to have something more fixed.
Anyway, I mean, this authority doesn't help you on that point because it uses the word may, not will.
Well, it has some indication because of the de anno.
And I don't think putting it in Latin makes it any different.
Well,
my limited knowledge of that.
I'm sure it doesn't make it any different. But I think that the Vice-Chancellor is taking that passage out of context, if I may say so. He has assimilated this to a mortgage. And nobody would expect a mortgage to be repaid within a year. That's a point that's going to come up in the cases as we go on. The mortgage says it'll be repaid after 6 months, but everybody knows it isn't.
But if you look at the way he begins his judgment is by talking about how what was then Section 40 of the relevant Act had been operated in practice. And he, at the top of page 437, he's taking a mortgage deed as an example.
Yeah.
And he says most mortgage deeds contain only a covenant to pay the principal with interest at a certain rate per annum on a day certain. After that, it accrues de die in diem, and the interest ordinarily is received half yearly from year to year. He goes on, it's difficult to see the distinction between interest so reserved and paid and that which by special agreement accrues on purchase money, which also goes on from day to day and may run on for a year or stop at any time on payment of the purchase money. So the word may is contemplating the possibility of it's going on for a year, but also accepting that it's possible it may not.
Well, this is why the Master of the Rolls in Re Cooper says there's some limit on it, because Bebb and Bunny doesn't appear to be fixing a limit unless you read it as I have read it, as implying a continuing obligation for a year or more. Now, maybe I have assumed too much from the assimilation of the situation there to a mortgage, but everybody knows that a mortgage is not typically called in after 6 months, even though, no doubt, most mortgage deeds to today say it can be.
Yes. But it's unlikely to have been a positive obligation not to pay the purchase price on the property until a year had passed.
No, I would accept that. But when we come on to the further cases, everybody has paid a great deal of respect to Bebb and Bunny, but I think all the judges have felt some discomfort with the decision as being insufficiently precise. And so they have tried to add to it some further requirement. And the further requirement is some investment-like quality or some permanence. It used to be the law that annual payments and yearly interest were assimilated. And annual payments had to be of a fixed amount each year. You had to know how much was going to go out. It didn't have to be the same sum each year. It could be done by a percentage, but it had to be fixed. And surely the concept of fixedness must inform the concept of yearly interest. Otherwise, it's not going to be yearly. Something which is inherently uncertain and fluctuating will not have the yearliness of quality. Anyway, Bebb and Bunny remained the law for about 35 years, and then in 1889, tab 38 in the bundle of authorities, Goslings and Sharp came along.
Page number.
It's page 634,
Thank you.
tab 38.
Yeah.
And leading judgment is given by Lord Esher, beginning at page 636. And he makes plain this is a case where a banker or any other man lends money for a specified time less than a year to be repaid at that fixed time. So that's what he's doing. And on page 637, he says, does the case, starting in the middle of the page, does the case which I've stated at first come with any of those? If it be a lending of money for a specified time less than a year, then it's said that those who lend the money may charge interest upon it in several different forms. And the learned judge makes clear that the fact that the interest is stated at a rate per annum is not telling you anything. Because at the top of page 638, where you've got 3 months period, it can't be yearly interest even if it's calculated by reference to a year. Then Lord Justice Lindley at page 640 in the Lord Justice Lindley is coming closer to what I said about Bebb and Bunny in this passage. The ordinary form of mortgage contains a covenant to repay the loan in 6 months, and if not then paid, a covenant to pay interest until the loan is repaid. Those are short loans, but in fact, as men of business, we know perfectly well that, except in exceptional cases, money lent on mortgages is very seldom repaid at the end of 6 months. So he then goes through and says, what is the real business case? And
This is where in point of business comes from.
yes, it's not the only place where point of business comes from. I think Viscount Sumner uses it in the Gateshead case. I think I've got that right. Anyway, we'll... And Lord Justice Bowen makes the point that the way the interest is calculated doesn't tell you whether it's annual or not. So that supports another criticism I made of Lord Justice Patton's paragraph 57, because he has taken account of the fact that the interest rate is, he said, yearly. And I think this passage, indeed the whole of that case, shows that the way the interest is calculated is not determinative of its quality. Now, Gosling's, of course, is undoubtedly a case where there were short loans. But then there were a trio of cases which dealt with the position where the position might very well be indeterminate.
Historic parallel between the practice in the Court of Chancery to which Lord Justice Lindley refers, 2/3 of the way down, and payments out to prudent creditors by an administrator, about what normally happens where the court pays out creditors against an estate, where it appears to have been settled practice by then that the payment out of the estate was subject to deduction of tax on the interest.
I believe that payment of statutory interest by administrators is very rare indeed. So I think there may not be a settled practice. It also has to be borne in mind that at periods, and I'm afraid I haven't checked which period we're in, all interest was paid subject to deduction. That's been changed years ago, but it may be. My learned friend in his case has set out quite a detailed history of, and of course Mr. Justice Hilliard in this decision has an appendix dealing with the history.
I mean, the similarity that struck me as a possibly relevant was one could loosely say that in a distributing administration, the administrators are making payments out of an estate to the persons who are entitled to share in what's in that estate. Estate being, by the time you get to the surplus, but in more general terms, the whole of what's collected in during the administration.
I think it's going to be very difficult to assimilate what's happening in an administration to the distribution of an estate once the court has said that we've have recourse to a statutory regime rather than a common law or original claims regime. So we have to determine what's happening by reference to the statute, which is, I venture to suggest, unique.
In Gosling and Sharp, Lord Justice Bowen, in the opening words of his judgment, appears anxious to limit the scope of what is there being said.
Yes.
He says, we are dealing with this, in this case, with short loans only, that is to say, with loans made for a period short of 1 year, loans which are not intended to be continued and are not continued for a long period.
Yes.
Yes.
The only point I'm seeking to get from Goslings and Sharp, well, one point is that the way the interest is calculated is irrelevant.
Yeah.
That seems quite clear. And secondly, from Lord Justice Lindley, that you've got to look at it as a matter of business. I certainly do not say that Goslings and Sharp establishes that statutory interest is short.
No. Well, certainly Lord Justice Bowen seems to think that if a loan which was initially intended to be short then runs over and interest becomes payable during the times that it runs over, then the case may be different.
Yes, and that's where we come to this trio of cases. Re Cooper,
Yeah.
Gateshead Corporation, and Garston. And I hope they are going to establish those four cases, the trio of cases and Goslings and Sharp, will establish these principles that an advance for a period of less than a year produces short interest. That's Goslings and Sharp.
Unless, in fact, it runs over.
That's the second proposition, which is an advance for an indeterminate period, which lasts for more than a year, where there is some kind of holdover or forbearance, again produces short interest, even though it's actually paid for more than a year, covering a period of more than a year. And I'm hoping to make that good by case of Garston Overseers and Gateshead Corporation. And then the third case, where I might need to add some more authority to the balance, is where an advance is applied by the creditor to acquire an investment intended to last for more than a year. And that produces yearly interest, and I get that from Re Cooper, from a case called Corinthian Securities, and Cairns and McDermott. Both of those are, when you're at my age, relatively recent cases. The first of those cases is, if I do it in chronological order, is recouper. It's in the first volume of Authorities at tab 39. The most important passage is at page 645. In the judgment of the Master of the Rolls. And the first paragraph on that page begins with the quote with which I opened.
About a judgment debt.
This is about a judgment debt. It's of course, the interest here is 7 days' interest, so it's certainly not long. But the important point is the court, in the middle of the page, 645, the court treats that as being a transaction to the knowledge and reasonable intendment of all parties, upon which yearly interest was payable in the understanding and contemplation of all parties, it being really in the nature of an investment. And then at the bottom of the page, he asks himself, now in the present case, I ask myself, is it possible to suppose this was a transaction in which anybody contemplated or intended anything permanent? Quite impossible to regard it that way. So this is where the idea of something permanent or an investment begins to appear in the cases. Since we talk in tax terms in terms of source, perhaps this is the source of the idea. You see it beginning to trickle here, but as we go through the cases, I hope it will emerge into a flood. That before you have annual interest, you have to have something like an investment. So if we then look at Gateshead Corporation, that is at volume A1, tab 35, begins at page 568. This is the case which gives me reason to have answered my ladyship quite so vehemently as I did, that something that runs over doesn't become yearly interest, because this is a case where something ran over. The Gateshead local authority improved the pavements, and the frontages then had a liability to pay, which stayed outstanding with interest at about 5%. And I think we see that in the middle of page 569. One has the impression that the amounts had been outstanding for several years. And we see at page 570 that Mr. Justice Rolat held that interest on the amount of the expenses was not yearly interest of money. That's important because we've got another Mr. Justice Rolat case coming up, and Mr. Justice Rolat knew a thing or two about tax. And here we have a judgment of Lord Sumner, and possibly with the rashness of youth, perhaps one doesn't quite think so much of the Master of the Rolls, Lord Esher, as one does of Viscount Sumner. Viscount Sumner is a really serious judge, and he has quite a lot to say about what is yearly interest. Beginning at the bottom of page 572, it said that the payment of interest in this case is a payment of yearly interest of money, because it is not shown that there was any agreement setting a short term or less than a year to the loan, which in fact the defendant was enjoying. The contention is that in all cases, except where such a period is fixed by agreement between the parties, there is a payment of yearly interest of money within the meaning of section 40, if the money remains for more than a year outstanding and interest-bearing. And then the judge rejects that completely. Going to page 574, about a third of the way down the page, as Lord Justice Lindley pointed out in Goslings and Blake, mortgages, though in the form the money may be repayable at quite a short term, usually 6 months, are totally different from bankers' loans for a short fixed term, such as 3 months, and are in point of business, so there's point of business again, not short loans at all, the express period of repayment notwithstanding. Going down a bit. Henry Cooper, which is the most recent case on this subject, Master of the Rolls with the concurrence of the other members of the court, said that he failed to see what ground there could be, saying that the transaction there in question was one to which the language of the Income Tax Acts about yearly interest could fairly be applied. I do not say that the present case is concluded by the decision in Henry Cooper, though I think it would be difficult to distinguishing it. But applying the principle underlying that decision, I am unable to see how the words yearly interest can apply to this transaction. There is no agreement for a short loan or a long loan. The debt is due and repayment is not enforced. Only in that sense is there a loan. Truly speaking, there is simply a forbearance to put in suit the remedy for a debt. And he goes on to say the repayment might have been enforced at any moment. Debt might have been paid at any moment. Lord Justice Patten distinguishes this case from our case by saying that the debts are not immediately callable. Well, the debts themselves have in fact been called because of the default in this case. There's a statutory moratorium, but if we look back to the original debts, they have become due and payable because of the default. And therefore, you cannot distinguish this case, Libby's case, quite so easily from the decision in Gateshead Corporation. We say, actually, this case, Gateshead, is very close to the facts of this case. There is, fair to say, a statutorily imposed moratorium. When you look at the debts, whether it be the proved debt or the original claim, what there is in relation to the statutory interest, if one treats it as distinct from the contractual claim, is something quite unique, but certainly not akin to investment. And then if we look at Garston Overseers, which is at tab 34, page 561, it's, the relevant passages on page 566. It's Mr. Justice Rowlatt. A body of overseers was claiming charitable relief. It only got charitable relief if it had yearly interest. It had been putting money on deposit at the bank. And Mr. Justice Rowlatt said it was not getting yearly interest. Section 105, the charitable exemption, seems to me to have been designed to exempt from income tax the interest paid on investments held by corporations. I don't want to prejudice the question of whether this is a charity, But the exemption given by the section is given, as I read it, on the yearly interest of the investments of such persons for the purposes for which they exist. That is how the section strikes me. And he talks about section 40. The cases under those sections are therefore the cases which must be looked at as throwing light upon what is yearly interest under this section. The broad result of the decisions in those cases is, I think, that yearly interest means substantially interest irrespective of the precise time in which it is collected, interest on sums which are outstanding by way of investment, as opposed to short loans, or as opposed to monies presently payable and held over, or anything of that kind. And what we say is that Mr. Justice Rolat has got to the kernel of it there. Before you can have yearly interest, you must have something like an investment. Now, the theme of an investment was picked up by Lord Anderson in Hay. I'm going a little slower than I thought, so perhaps I might just refer to it. It's tab 42, volume 2, page 710. And the relevant page is the right-hand column on page 715, and the top left-hand column on page 716.
Can I just mention, this series of reports isn't the easiest to get our hands on, the Lord Justice Clerk's judgment seems to have been cut off in the way it's been reproduced. We jump from page 381 internal to page 384. Do you see what I'm meaning, Mr. Gilbert? Yes, so we leave Lord Justice Clerk mid-sentence. So it'd be helpful if those behind you were able to provide us with a complete copy of the judgment.
There may be a cases report.
Yes, very, very, very likely.
We'll provide you with all.
Thank you very much.
So what are we getting from this case anyway?
It reinforces the need for there to be an investment.
Yeah, but I mean, it's just, so it doesn't really add anything to Justice Rowland.
No.
Yes, a measure of permanence and was of the nature of an investment.
Then and it shows a uniform approach, which is reinforced by the decision in Corinthian Securities, which is in the first volume of Authorities at tab 32. The relevant passages on pages 535, 536. The question here was whether a debtor could deduct interest from a payment he was making, and that depended on whether it was yearly interest or not. And at letter G, counsel cited some words from Lord Anderson in Hay. There is a tax cases report. I cannot agree with this contention. The words short loan are not used in the statute. It's a mistake to place too much emphasis on them. The real question is whether the interest payable is yearly interest of money. Interest is yearly interest of money whenever it is paid on a loan which is in the nature of an investment, no matter whether it is repayable on demand or not. An ordinary loan on mortgage is usually, in point of law, repayable at 6 months, but it is still yearly interest of money. On the other hand, when a banker lends money for a short fixed period, such as 3 months, and is not intended to be continued, such a loan is not in the nature of an investment. It is not yearly interest of money, but a short loan. That's shown by Goslings and Sharp, with Lord Justice Lindley referring to the ordinary mortgage. In point of business, therefore, a mortgage is not a short loan, but a banker's loan of 3 months is a totally different thing. And looking at the agreement in this case, plain to me that this loan was made as an investment. So there is a further reinforcement of the need for investment and permanence. And the next case is Cairns and McDermott at tab 29.
Can I just ask you about the importance of the investment? Is it because it indicates that the parties intend that there's not going to be a demand made in the near future? Is that what the word's being used to denote?
It's being used to denote something which is more than a year in term, at least. And in a minute, we'll be going to look at the requirement of permanence, which requires something fixed, something in the nature of a fixed setup, I think is the phrase used. I may not have that quite right, but
It's not the term as such, because, as you rightly say, the judges emphasise in point of business. The term may be requiring payment earlier, but the business reality is that the parties are expecting it to run on. I think that's where that seems to be the thrust of the case law. Is that not right?
I think they're expecting it to run on rather than being inherently uncertain. There's a difference between the uncertainty, which we have in this case.
But there may be an entitlement by the creditor to demand, but nevertheless, in point of business, the loan may well run on.
Yes.
Yes. Thank you.
In Cairns and McDermott, I think, to answer my lady as fully as I can, it is looking for something that the parties expect and intend to run for more than a year. Intention has been referred to in more than one case, and indeed in Cairns and McDermott, which we're going to look at, tab 29, page 506. The relevant passage is on page 509. Letter H. Well settled that the difference between what is annual and what is short interest depends on the intention of the parties. Interest payable on a mortgage, or indeed a shorter period, will still be annual interest if the intention of the parties is that it may have to be paid from year to year. I would personally wish to avoid the use of the term investment as providing any sort of test in the context of whether interest is annual interest, notwithstanding its use in the latter case, because it's possible to have short-term and indeed a very short-term investment, e.g. overnight deposits. On the facts found by the Commissioners, the loan to Mr. Cairns was never intended to last for more than a few days. Now, I think Sir John Donaldson's deprecation of the use of the term investment is not to say don't use the term investment at all, but bear in mind that if the investment is to last less than a year, even though it's an investment, it won't produce yearly interest. To have yearly interest, I think the cases show you have to have this investment-like quality. And you also have to have the intention that the period will last for a year or more.
In part of the thinking we saw in the Victorian cases seems to have been essentially pragmatic, that it's just inconceivable that Parliament could have intended tax to be deducted and remitted to the revenue whenever there was a short-term loan, because it would cause chaos even in the financial markets in Victorian times. And so they're driven to the conclusion that the phrase must be intended to have to be concerned more with long-term arrangements.
And that remains the law today. My Lord, you say the Victorians, even in Victorian times, the Victorians were running an empire without a fax machine.
Yeah, yeah.
Their markets were vastly sophisticated. What I think I can get out of the cases is that the revenue in paragraph 23 of their case, page 70 of the bundle, say the matter can usually be answered by seeing how long a period the interest covers. And in our submission, that is plainly wrong. I mean, Gateshead shows that that is wrong. The period for which the interest is paid, the event is neither here nor there. You have to look to the quality of the obligation. So the Court of Appeal has relied very heavily in its decision on the cases about damages. And there are 5 cases which have been taken into account in that connection. 2 of them are the case of Barlow, which is in the first volume of Authorities at tab 25, and also the case of Barnato, which is at tab 40. And unless your ladyship particularly want me to take you to them, all I'm intending to say about them is that they are in fact cases where there was an agreement that the debtor owed money to a creditor, and it was agreed that he would pay interest for a number of years. So those were, in fact, cases of agreed loans, in effect agreed loans. They arose out of litigation or potential litigation, but they were compromised by agreement. And they are indeed long-term arrangements, so it's not surprising that they produced yearly interest. And the cases which deal with damages strictly are Westminster Bank and Riches, Regal Hastings and Gulliver, and Jefford and G. Now, the way the court has worked in all of these cases is to say, you the debtor, have owed the claimant a certain sum of money for a number of years. You will pay that sum with interest. And those cases are examples of the third type of liability, which I put on the diagram sheet. The leading case, I suppose, is Riches, which is in the 4th volume of Authorities at tab 62. Viscount Simon at page 1345 explains the basis of the decision. It says the added amount may be regarded as given to meet the injury suffered through not getting payment of lump sum promptly.
Oh, I found it. Yes, thank you.
And we didn't put the decisions below into the bundle, but if we go back into the decisions below, I think Mr. Ritchie's suffered a wrong about 7 years before judgment was given, and the court below says he's been owed this money for 7 years. The same thinking in Lord Wright's speech at page 1348. A third of the way down the page, Lord Wright says, in either case, the money was due to him and was not paid, or in other words, was withheld from him by the debtor after the time when payment should have been made in breach of his legal rights, and interest was a compensation. So there again is the establishment of a debt some years before declaration of the debt, and declaration that it was to be paid with interest. And Lord Simons, at page 1354 to 1356, says the same thing.
Sorry, what are you saying about these cases?
These are cases where there has been a liability outstanding for years,
Yeah.
and then interest is declared. You will pay interest for the 7 years, starting on such and such a date and ending on another date. And of course, that's yearly interest. So these cases are actually illustrating the principle that where you have something long-standing, that is intended to be long-standing, then there, and we know it's intended to be long-standing at the date we're measuring it, then what you're paying is yearly interest.
I'm sorry, was this case actually concerned with yearly interest?
No, this case was not concerned with yearly interest.
It's simply saying that it's interest.
Question of interest. It was taken as being concerned with yearly interest in Jefford and G, which is in the second volume of Authorities at tab.
What the case seems to be telling us is that when you're deciding whether something is interest or not, it doesn't really matter whether it's called damages or compensation or whatever. It's its inherent character that's important. And if it's compensation for being out of your money, effectively, then it's of a nature of, then interest is the nature of what it is.
Yes. But I think it is also important that these cases are establishing that it is as if the debt was created 7 years before, so that, I'm choosing 7 years as an example, so that you do have a 7-year term, which at the time the interest obligation is imposed is a known term.
Yes, it wasn't a debt that was intended to run for 7 years when created. It might have been a purely transactional debt, rising out of a contract payable immediately.
Yes.
But you say that's affected by the fact that by the time interest becomes payable, you've got to judgment, payment for which compensation is due.
Yes.
That's right. Why isn't there an analogy in the administration situation? If it's only years after the proof, the cut-off date, that a surplus arises.
Because I have throughout a continuing source in the damages cases. The wrong is done on day one. If and if you know that the wrong has been done, you know that interest is going to be paid. If we look at my chart, at point B, you don't know whether interest is going to be paid or not. You haven't got the faintest idea. You don't know whether you're going to get interest. You don't know what period you're going to get it for. And you don't know what amount it's going to be, because that's going to be dependent on the surplus. So,
Yes, but in the case you're referring to, it obviously is dependent on the solvency of the debtor. So you don't know, subject to his solvency, you don't know whether you're going to get it.
that's a question of collection, not a question of measure.
Yes, so I see. So you're, could put it this way, that there is, assuming the cause of action is well founded, there is an entitlement to interest from the date when the cause of action arises, and the court's award of the interest is, in one sense, of a declaratory nature.
Inevitably declaratory. Which is of a totally different quality from whatever arises, if anything, at B. If I'm right and the source arises at C, at D, it only lasts from D to E, and you can't make a comparison with the damages case because you haven't got something arising at B, which you do in the damages cases.
This was a discretionary power to riches. Was it really declaratory? It was a discretionary power to award interest under the Law of Miscellaneous Provisions Act. Looking at the opening words of Lord Simmons' speech on page 1352.
But some of these cases, some of these cases are to do with equitable jurisdiction, where it's clearly declaratory. And it's unlikely that there is a difference between declaratory cases and Law Reform Act cases.
Not a case where there was necessarily an underlying contract debt which carried interest. If it was damages for some breach of contract, you'd only get interest from the period when you had a cause of action if the court gave it to you under the Act. And although, of course, you did usually get it, it was in fact discretionary, wasn't it?
But it's consequent upon the declaration of liability on day one. And that is what makes a fundamental difference between the facts of Libby's case and all the other cases.
But why is Libby's case a weaker one? It seems to me if the company was, at the cut-off date, you prove your debt, it doesn't really matter whether it carried interest up until the date of proof. And you know that if the company is going to be solvent, you don't know whether it's going to be solvent, but if it's solvent, if you can afford to pay, you're going to get statutory interest. It's not a question of discretion at all.
But you have no idea when or what.
It'll carry interest at the judgment date from the cut-off date if the company's if there's enough in the pool, the administrator's realisations, to pay for it.
In this case, you didn't, because the only reason they're able to come and tell you that there has been a point D and a point E on the chart is because the parties have resolved their differences and entered into a scheme of arrangement.
Well, is that right? My recollection was that Lehman unsecured debt was trading over 100 from not awfully long after the liquidators, after the administrators said there was going to be a surplus.
I mean, that's maybe because people were speculating in it.
No doubt.
One has to decide, first of all, whether the source is the proved debt, the original debt, the proved debt, or, as we say, the right to statutory interest at the time when it becomes known in point of business that you've actually got that right. And up until point D, this is wholly speculative. The administrators could have decided to put the company into liquidation and created the lacuna, which is shown in Waterfall 1, I think it is, which is in the second volume of Authorities, tab 55, paragraphs 117 to 121. The quality and nature of the right is completely different. I think it's perhaps useful to look at the way in which Viscount Radcliffe was talking about annual interest. Freer, second volume of Authorities. One. And Viscount Radcliffe explains the idea of division of income at pages 699 to 701. Then he picks it up again at pages 707, 708. He's talking in a totally different context. This is about whether you can deduct things, but it's nonetheless relevant. About the distinction between short interest and annual interest. He makes a distinction at page 428 between interest on a long-term mortgage or charge of a life annuity against the interest on 24 hours money. It's possible to see a real difference between their respective impacts on the payer's true taxable income. In the first place, there's something like a permanent setup, under which the man's income accrues to him each year, subject to a fixed and recurring charge for this outgoing. The second, the short interest, can be regarded as merely part of the cost of getting, using, and returning money. So there's the reference to a permanent and fixed setup. Something like a permanent setup. Now, you haven't got anything like a permanent setup in this case. point B, you just do not know whether you're going to get statutory interest. At point C, you may have a better idea, but you don't know until point D. Because if there had not been a scheme that was agreed between the creditors, there would still be litigation going on in this matter. And that would be litigation about who got what bit of the surplus. So it would have remained inherently uncertain. And it may be, we would in those circumstances be saying, in point of business, the source has not yet been created. We are certainly able to point to the date at which a source is created, date D here, because that's when people know what's going to happen. An investment usually requires the use of funds to acquire an asset which produces a known return. That's what gives you an investment. Nobody getting statutory interest did that here. You're looking at the measure as between the creditor and the debtor. You're not looking at a purchase price that C pays to T, or that C gets paid by T. That's not the investment you're looking at. The question you have to ask is whether what the creditor did to the debtor, the original creditor, did to the debtor, is an investment. In our submission, the situation here is completely different from the situation in the damages cases. There, when the declaration is made, when the source arises, it is known there is a future term. The source in those cases is the wrong. The source is not the order of the court. The source is the wrong done years before. And that is why the cases are different. Another difference is the possibility of the lacuna. Anybody holding this debt thinks it may go away. The right to statutory interest may disappear if the company goes into liquidation, which I believe was a real possibility. See this idea that the debt has arisen years ago in the damages cases, again in Regal Hastings and Gulliver, in the second volume of Authorities at tab 52. On page 851, in the right-hand column, I have to deal with the facts in this case, where the House of Lords held in 1942 that the defendants, the directors, are to be treated as having had, each of them, since 1935, certain sum in trust for the plaintiff, and the directors must be taken to have invested it at the moment they received it, and therefore must pay interest from that moment to the time, 6.5 years later, when the House of Lords declared the defendants liable. There is a clear indication that the source relates back to what I might call day one, which is not the case here. And the only case which actually says that the interest in the damages cases is yearly interest is Jefford and G, which is in tab 43 in volume 2.
That was an award of interest in equity, presumably.
I believe so.
Again, discretionary, isn't it?
Yes. But once awarded, it's running from day one.
Well, as is statutory interest in this case. I mean, it runs from the whole period of the withholding of the money from the start of the administration.
If you take, well, no, my lord, it doesn't actually. It runs from A to C on the chart.
Yes, until repayment, yes.
And
It goes on running past C until it's paid, doesn't it?
Well, the final
Oh,
dividend
no, it
was C.
doesn't. No, it doesn't.
no, it doesn't.
Yes.
And not only that, it's not compounding. You're not getting any benefit at all from being out of the money, which is a very important point.
Well, if you're getting interest at 8%, it's hard to say you're not getting a benefit from being out of the money. I mean, it was an extremely valuable asset. It was one of the best investments available, I would have thought.
It may have been one of the best speculations available, my lord. I don't think, I certainly would not have invested my money in Lehman debt. You have to be a very bold person to do it. And no doubt there are bold buccaneers out there, but they're not often called investors.
Anyway, on Jefford and G, I mean, you're accepting that it is the damages situation, it is yearly interest, aren't you? Or at
Well,
least
it seems to me that it's yearly interest because it clearly covers 7 years
Yeah.
during which the liability is outstanding. Now, the liability is not outstanding in the case of the statutory interest. Mr. Justice David Richards tells us it is not outstanding. If we go to the third volume of this, tab 56.
That was in the context of the Bauer and Maris issue, was it?
Yes, but it's a point of nobody's challenged this holding as to the nature of the statutory interest. The right to interest out of the surplus under Rule 288.
Sorry, where are we looking now?
I'm sorry, my lord. It's page 1041, page 51 of the law report, tab 56, in the third volume. Paragraph 149. Right to interest out of the surplus under Rule 288 is not a right to the payment of interest accruing due from time to time during the period between the commencement of the administration and the payment of the dividend or dividends on approved debts. That, to us, seems to say that it is not accruing on the approved debts. It goes on to say the dividends cannot be appropriated between approved debts and interest accruing due under Rule 288 because at the date of the dividends, no interest was payable at that time pursuant to Rule 288. The entitlement under Rule 288 to interest is a purely statutory entitlement arising once there is a surplus and payable only out of that surplus. That is why I am making my submissions that the source doesn't arise till D on my chart. I hope I've got the letter right. Yes, D.
That arises from the interpretation of Rule 2887, does it?
Yes.
Any surplus shall, before being applied, be applied in paying interest on those debts in respect to the periods during which they have been outstanding since the company entered administration.
Yes.
Is that an indication that's what they're about? accruing in respect of a period since the administration?
Well, Justice David Richards, as he then was, said they're not accrued.
But he wasn't. What was he concerned with this issue?
He was concerned with the question whether, when a dividend was paid, a creditor could, at a later date, once he was proving for interest, or proving is the wrong word, once he was seeking interest, claim to have appropriated the dividend to accruing interest, under a case called Bound, I think. That was the issue that the judge was dealing with. It came to the Court of Appeal and we upheld the judge.
Yes. Well, but...
And so what the judge is saying is you couldn't say 2 years previously, when you've got an interim dividend on one of your points on your graph, let's say the first interim distribution in November 2012, that you could allocate that to interest. So as not to suffer a reduction in the capital amount in which later, under the rules, you would get paid interest.
Well, I don't believe that interest can accrue at one time for one purpose and at another time for another purpose. It either accrues or it doesn't accrue. The difficulty for my learned friends, if we're going to go away from this method of interpreting what the obligation is, we get pushed back to the original debts. The original debts are something like £13 billion, of which 12 billion are short. If we're pushed back to the original debts, and my learned friend is relying on National Westminster Bank and National Bank of Greece, I think I've got the nationals in the wrong place there, that pushes us back to the original debt, which neither party has argued for, accepting this passage. But if we are pushed back to the original debt, Gateshead shows that the interest is short. And if we are not going to take what Mr. Justice David Richards said as correct in relation to when the interest arises, there really is no reason why we don't go back to the original source. This is the bit that pushes us forwards. And it may be that going back to the original debts is not the worst thing in the world that could happen. After all, anybody paying interest has to decide whether he's paying yearly interest or not. It's only the peculiar circumstances of this case which make this application desirable. People have to do it sort of every day. Anyway, if you're taking what Mr. Justice David Richards says is correct, that is pushing the date at which the source rises far into the future, and you cannot compare it to the right arising when a tort is committed or a breach of trust is committed. And if I can just complete my comments on Jefford and Lee. It's tab 43 in the second volume, and the relevant page is 734.
This was again the award of interest under the 1934 Act on damages, is it?
Yes, but notice page 734 at letter A, interest should not be awarded as compensation for the damage done. It should only be awarded to a plaintiff for being kept out of money which ought to have been paid to him. So there again, there is the original debt which ought to have been paid to him. And if by the original debt here we mean the original debt, I'm talking about this case, Libby's case. If here we talk about the original debt as the source, the interest is short. It's exactly like Gateshead. If we're talking about the proved debt as the source, the interest is uncertain. And there is a moratorium which is holding up the payment of an immediately payable debt. So again, you have something that is inherently short. You have a forbearance or a moratorium, which Garston, Overseers and Gateshead shows is short interest. And if, as we say, the source is what happens at point D, you do not have the long term for which the damages cases apply. That runs backwards from D to B. You have only the period D to E. So that you never have an equivalent of being kept out of money. We get the same concept on page 735 in Jefford and G. Letter F. Court always awards compensation for them in one lump sum, which is by its nature indivisible. Interest should be awarded on this lump sum as from the time when the defendant ought to have paid it, but did not. Only from that time that the plaintiff can be said to have been kept out of the money. So here again, you have the long-term loan. In all of these cases, you effectively have a borrowing of money, a lending of money by the wronged person. There is, in today's terms, a rather interesting passage, and they're not relevant to this case, on page 738, between letters F to G.
On the previous page, he simply says, when the court awards interest, it is yearly interest of money, see Richards and Westminster Bank.
Yes.
But that's not what Richards actually says, is it?
No, it is not what Richards says. This is the only authority for saying that this interest is yearly interest, and it relies on Richards, and I think it's generally agreed that Richards does not decide that. But we do see a considerable difference between...
But I mean, you accept that even if that's not the right source, it's correct?
I'm convinced, yes.
I mean, I think that the problem was that the wording in the old Schedule D was about yearly interest or other annual payments. I mean,
Yes, yes.
It's like ambiguous.
There was certainly... I think it was not appreciated when Jefford and G was decided that the previous cases were cases where interest had to be withheld in any event, whether it was yearly or not. Because at the time, I think I'm right in saying, interest was...
Yes, I mean, Mr. Justice Hilliard gives a quite helpful account of the variations in language over the centuries.
Yes, it does. But while it helps with this, to see why Lord Denning said it was yearly interest, I'm not sure that it actually illuminates the question of whether the interest is yearly or not. What I think is most illuminating is what Viscount Radcliffe said in Freer about the need for a permanent fix-up, set-up. And can I just emphasize four features of our case, which are not actually present in any other case. First of all, there is the question of source. Question of what we're looking at. And we say that Mr. Justice David Richards has given a definition of what is the source in his judgment, shown you, which is unique and takes us away from the original debt. There is a second problem with identification of the debt as the source. The problem is, and this is quite a major point, I'm sorry to come to it a bit late, the problem is that the source disappears at point C. Proved debts are all gone at point C. Mm-hmm. If you take the proved debts as the source, they've all disappeared at point C. How can they then produce taxable interest, which arises at point E, which is in a year after the source has disappeared? If we look at the revenues case, core bundle tab 6, paragraph 17, footnote 22,
Sorry, I missed the page.
page 63, 64.
Thank you.
Footnote 22, and see the National Provident Institution and Brown for the general principle that in order to be chargeable to income tax for a particular year in respect of income from any source, a person must possess that source of income in that year. Well, now, nobody possesses the source of income in 2018-19 when it disappeared in 2014-15.
Now, Mr. Goldberg, you are out of time now, so you're going to have to draw your remarks to a close, I'm
Yes.
afraid, to allow time to Mr. Gani.
Yes. Well, my Lord, I think if I can just make two other brief points. Thirdly, the administrators had to proceed with all due speed. So nobody knew how long this was going to last. The need for speed is brought out by the decision of Mr. Justice Hilliard in the matter of Lehman Brothers in volume 2, tab 53, and in Waterfall 2 in volume A1, tab 28. Both of those decisions emphasize the need for the administrators to proceed with speed, which pushes the liability to the shorter end of the spectrum. And then there is the problem of the lacuna. And all of these features affect the source no matter how it's identified. And they are not features that will be found affecting any other type of source. And in our solution, they all push the conclusion towards that the interest here, the statutory interest, is not yearly. Unless there's anything you would like me to deal with.
No, thank you very much indeed, Mr. Goldberg. Mr. Bayfield, have you anything to add? Mr. Gammy.
My lady, my lords, let me try in the time that remains before the short adjournment to explain why we say that this is yearly interest, and then maybe after the short adjournment I can deal with some of the points that my learned friend has made in his submissions. Imagine, if you may, for a moment, that on the 1st of July 2008 you extended to Lehman Brothers International Europe a short-term accommodation of £100 million for 6 months. I've set the figure at a fairly modest range, given the figures that we're already talking about. Your money is at risk on those agreed terms in Lehman's business, and whether you are repaid depends upon their business not failing. So to your consternation, on the 5th of September 2008, Lehman enters administration. Not all is lost, however. Your expectation of being repaid £100 million plus interest to the 31st December 2008 has disappeared as such, but you can and do prove in the administration for 100 million plus any outstanding interest at the 15th of September 2008. Your money, in other words, your entitlement to be repaid £100 million remains at risk in the company. Lehman's may in fact be solvent on an assets basis, but has just run out of cash to pay its debts. Alternatively, your money may not appear to be represented by any assets, but it may be recouped in whole or part through the judicious conduct of the administration by the administrators. The main difference in your position, and for present purposes it is a fundamental difference, is that previously you had agreed to lend short term, but as a result of the administration process, your money, now represented by the debt that you've proved in the administration, is locked in the company for as long as it takes the administrators to sort out its affairs. Essentially, you've been converted from a willing short-term lender to the company into an involuntary long-term investor in the company. But at least, if it turns out that there is a surplus, you will receive interest on your proved debt at the annual rate of interest provided for under the rules. So is any statutory interest that you eventually receive yearly interest or short interest? We say by every criterion it's yearly interest, and I'll go through 5 reasons why I say that. First, your contractual entitlement has been replaced by the proved debt, but your money, in the sense of what you hope to be returned from the company, is as much invested and at risk in the company as it ever was. But your investment, the proved debt, which we say is the source of any interest you may receive, and just by way of clarification, we don't say that arises at B, we say it goes back to A, is no longer the short-term accommodation you intended, but as Lord Justice Patten said in the Court of Appeal, it is unlimited in point of time. You are in it for as long as it takes. That was not your plan when you first lent £100 million to the company, but it is what has happened. As President Kennedy said when he was asked to explain how he became a war hero, he said, "It was involuntary. They sank my boat." Your participation in the Lehman's administration may have been involuntary, but just as Jack Kennedy won his Navy and Marine Corps Medal and Purple Heart for his actions after they sank his boat. So you have become a long-term investor in the company. Second, it is yearly interest because once you'd proved your debt in the administration, you would know that whatever interest you might eventually receive would be calculated on a year, as Lord Justice Byrne put it in Gosling and Sharp and Blake. My learned friend took you to that, so I won't take you back to it because I think you noted the relevant passages in his judgment, but for your reference, it's in the First Authorities Bundle, tab 38, at page 641. And that was calculated on a year at the specified rate. It would never just be a matter of looking at interest currently due for a period of less than a year and seeing whether it arises on a short-term loan, as indeed was the case in Gosling's. Third, it is yearly interest because although the administration may have triggered a default on your original loan, whether it was short-term accommodation or longer-term debt, you cannot demand repayment. This is not a case of forbearance on your part to sue for money, in respect of which you had already made a demand, as in Gateshead Corporation and Lumsden. All you can do is prove your debt and wait for the statutory scheme to take its course. One only has to reflect on Gateshead Corporation. There, the corporation spends money on maintaining or improving the roads and is entitled to collect some of that money from the frontages on that road. So it sends its demand for the amount to be paid, and the amount is not immediately paid, for which, of course, the corporation could sue immediately, but it chooses not to, and interest is just allowed to run. And the mere fact that that runs beyond a year does not convert what is essentially interest on an immediately payable debt into yearly interest in those circumstances. Of course, as Viscount Sumner noted in Gateshead Corporation, if the corporation had reached some formal agreement with the frontager that the money could remain outstanding for a period, then the answer might have been different. But all that happened was that the corporation did not sue for the money it had demanded, and interest then ran on the unpaid debt. Fourthly, I say it is yearly interest, even though you will only receive interest if, as and when a surplus emerges, which of course it might never do. But in a general sense, that's true of every loan. Interest is contingent on the money being there to pay it. And in the context of administration, the requirement for an overall surplus before any statutory interest becomes payable is hardly an exceptional matter. Payment, however, does not depend upon the administrator's discretion. Night follows day without exception in the case of statutory interest, even more so than it does in the case of equity, and it's the administrator's grounds of appeal in the first tab of the core bundle at page 19, where they talk about interest being paid as a matter of equity as night following day. I say night follows day even more certainly in the case of statutory interest if a surplus emerges. The fact that statutory interest is only calculated once a surplus has emerged does not alter the nature of the calculation that falls to be made, and by reference to which the payment is characterised as interest. Substantively, it is no different from a case in which you are jointly developing a North Sea oil field, and it emerges as the development proceeds that your tract of the field proves to contain more oil than originally estimated, and there therefore has to be some recalculation. That was the situation in the case of Chevron versus BP. It's at tab 30 in the first authorities bundle, and at page 519. This is the end of the decision there. It was the question whether or not the adjusting payments that had to be made between the various participators in this oil field included yearly interest. And if we look in particular on page 519, we can see that Sir Robert McGarry, the Vice-Chancellor, is talking about whether or not it's the contingencies and the absence of a pre-existing debt gave rise to yearly interest, in particular at if we take it from F, on page 519, so counsel for the Chevron group contended that since it could not be foretold which of the operating parties would become debtors and payers, and which would become creditors and receivers, the liability of the former was contingent, not vested, and so there was no debt or other sum on which there could be interest in the true sense of the word. I don't think that this follows. I cannot see why the contingency should deprive the so-called interest of being the quality of true interest. And then he gives an example. And in the next paragraph, counsel for BP Group naturally relied on the decision of the House of Lords in Riches versus Westminster Bank. There it was established that when the court exercised the power conferred by the Law Reform Miscellaneous Provisions Act 1934, section 3, subsection 1, to make an award of interest when giving judgment for the recovery of a debt or damages, the sum awarded as interest was truly interest of money for income tax purposes. The power is discretionary. If an award is made, it may be made on the whole or any part of the debt or damages for the whole or any part of the period between the date when the cause of action arose and the date of the judgment, and the rate of interest is to be such rate as the court thinks fit. It's therefore plain that until the court has made an award of interest, it's wholly uncertain whether any interest at all will be given, and if it is, for what amount it will be. It's also clear that when a sum of interest is awarded covering a period which may be many years in length, that sum comes into existence uno flatu by the judgment of the court. Despite the characteristics, the sum so awarded is of income and not a capital nature. This depends not on the statutory use of the word interest, but on the substance and nature of the award. Counsel for Chevron Group contended this decision did him no harm, although the obligation to pay interest was created by the judgment. The award made on the basis that the defendant ought to have paid the money sued for at an earlier date and had not done so. The interest awarded was interest in respect of the plaintiff being wrongly kept out of his money. That was not in the present case, where the operating parties had duly paid all that was due from the contract at the time that it was due. I do not think that this point, or indeed any other point, suffices to distinguish the Riches case. So you can see the arguments being made, and it's plain from the decision in Chevron versus BP that everybody was treating this as yearly interest. So I say there's no substantive difference in what we have here with the statutory scheme, and I also say that there's no substantive difference between interest that accrues as a result of a trustee's default or a personal injury claim. The interest can only be awarded and calculated once an account has been drawn up or damages assessed. And there is no substantive difference between a situation in which a breach of trust has occurred or injury suffered and the present case in which a surplus must emerge for the statutory entitlement to interest, for interest to be paid. I'd say it's somewhat artificial to say that amounts are accruing due in the case of a trustee's account or personal injury damages, when the actual figure on which interest is said to accrue is unknown, so that the interest actually payable can only be calculated at the end of the day, and the award depends upon the exercise of judicial discretion. The case to which, or two cases to which Lord Justice Patten refers in his judgment are Target and Redfern, which is at tab 59 in volume 3 of the authorities. Lord Justice Patten, I think, had reason to remember this case well, because I think he was the counsel in the House of Lords who put the argument that was rejected by the House of Lords in that particular case. And the point was whether or not, in relation to a payment away by a firm of solicitors of a sum of money for the purchase of property earlier than they should have paid it away, and therefore was paid away in breach of their trust, whether or not you drew the line there and said that they were liable to make good the money that they paid away on that particular point in time, or whether the fact that the client got exactly what he was expecting, in other words, the purchase of the property and security over the property, meant that there was no loss, if you like, attributable to the breach of trust. And as the House of Lords made absolutely clear, you can't just draw a line at the breach of trust and say that's what's due. You have to look at what happens later to see whether, in fact, there is a loss of that is attributable to what has been the breach. And that, I think, is the point that Lord Justice Patten is making, that you don't actually know until a much later date as to what, in fact, the position is and whether, in fact, there is any amount due or what it is, and therefore you can't say that there is something accruing from the point of the breach of trust. It's only when it comes to be determined at the end of the day what has flown from the breach of trust.
Regal, Hastings and Gulliver, it all depended upon what the fiduciaries did with the information which they wrongly abstracted from their company and used for the setting up of a...
Indeed, my Lord.
Figure on which they ended up having to pay interest was presumably the court's much later valuation, if you like, of the benefit to them of that wrongfully obtained opportunity.
Indeed, when you actually finally draw up an account to work out what has flown from the much earlier breach of trust. And the other case to which Lord Justice Patten refers was the case of Wallersteiner and Moyer, which is at tab 60, which I think just makes the point that the award of interest in that particular case was an exercise by the court of its equitable jurisdiction, which again makes the point that in these sorts of cases, it is, I say, unrealistic to try and draw a line between the accrual of interest or the payment of interest in those cases, which is taken to be yearly interest, and the payment of interest that we have in our case, where in fact there is a greater certainty that interest has to be paid once it's shown that a surplus has emerged. And I say that the Court of Appeal could see no rhyme or reason why you distinguished between the two situations. By contrast, Mr. Justice Hilliard relied on Justice David Richards' decision in Waterfall 2A, where he was dealing with the principle of Bauer and Maris, which my learned friend has referred to, and in particular the nature of the right to statutory interest. And if we just look briefly at that, it's at tab 56 in the third authorities bundle. And the particular paragraph in the decision is, there are two paragraphs, 149 and 154. They're on page 1041 of the bundle. And we can see in paragraph, having looked at Bauer and Maris, Justice David Richards decides at, or says at paragraph 149 at the top of the page, the right to interest out of a surplus under Rule 2.88 is not a right to payment of interest accruing due from time to time during the period between the commencement of the administration and the payment of dividend or dividends on the proved debts. The dividends cannot be appropriated between the proved debts and interest accruing due under Rule 2.88, because at the date of the dividends, no interest was payable at that time, pursuant to 2.88, because it's obviously contingent upon the emergence of the surplus. But that doesn't alter the fact that when the surplus emerges, the interest is calculated over the period, which in my learned friend's diagram is period A to C, as we saw. And then at paragraph 154 at the bottom of the page, we need to read the full paragraph, because in fact, both in Miss Justice Hilliard's decision and in the grounds of appeal, a section of the words are omitted from paragraph 154. So it says, Mr. Dicker submitted that the principle in Bauer and Maris was more fundamental than simply requiring payments on account to be treated as applicable first to interest payable at the date of those payments. It was, he submitted, intended to reflect an underlying principle that in an insolvency, creditors should not be prejudiced by the late payment of debts. Those words are, I think, omitted in both Justice Hilliard's decision and in the appellant's grounds of appeal. What they go on to say in the next words, the statutory right to interest arising under Rule 2.8 can be regarded with hindsight as having accrued on a day-to-day basis since the commencement of the insolvency process, albeit contingently on there being ultimately a surplus. Once the event occurs, the right to interest is treated as having accrued during the relevant period. And then he says, I do not accept this submission, but this submission is what has been submitted in the first two sentences of that paragraph, not what is said about accruing day-to-day contingently, whereas Justice Hilliard and the appellants present it as if what he's not accepting is the submission about contingent interest. So I say that is an error that Mr. Justice Hilliard made in not including what was the actual submission being rejected by Justice David Richards. But of course, Lord Justice David Richards was a member of the Court of Appeal in this appeal, and so he was well placed to know exactly what it was he meant by those two paragraphs, 149 and 154, and of course he agreed with Lord Justice Patten. I had a fifth point, but I think I will deal with the fifth point after the short adjournment.
Very well. And the court will adjourn.